Okay, this will be some number practice. This is the 100, 120 class. For the record, 7,118,239, 689, 50%, 1,874, $17.69, 7,622, $52,055, $24.86, 1,298,373, 2,700, $6.35, 9,146, 10.25, $89.45, $250,192, 10 million, 75%, $119.59, $405.06, $66,000, $83,670, $50.99, 1,200, 9.75, $28.79, 3,700, $152,439, 13,049, 8,834,746, $6.50, 100%, 15,209, $47,010.12, 18%. These are some telephone numbers. 527-3693, 676-1954, 981-3411, 774-5092, 583-6073, 479-2515, 972-6855, 609-8595, 714-1332, 985-3156, 881-2039, 364-4436, 701-8178, 824-6259, 537-4601, 707-0019, 763-9240. Some times. For the record, 12:10, 10:58, 2:14, 7:20 a.m., 8:42, 5:26, 4:33, 6:01 p.m., 9:45, 1:15, 3 o'clock, 6:55, 11:25, 9:30, 7:12, 6:50, 4:35 p.m. Putting your colons in there. These are some ordinal numbers. 35th, 3rd, 60th, 22nd, 11th, 32nd, 23rd, 68th, 71st, 13th, 46th, 32nd, 94th, 103rd, 12th, 84th, 62nd, 99th, 17th, 39th, 115th, 93rd, 44th, 2nd, 50th, 11th, 210th, 83rd, 20th, 4th, 33rd, 101st, 317th, 53rd, 80th, and 1st. These are days and dates. For the record, Wednesday, October 31st, Sunday, January 3rd, Friday, April 27th, Tuesday, July 18th, Sunday, May 1st, Monday, September 15th, Saturday, August 21st, Wednesday, February 17th, Saturday, March 2nd, Tuesday, December 20th. Friday, November 15th. Thursday, July 13th. Monday, August 26th. Thursday, June 11th. Some sentences for the record. The outfit cost $79.99, and the new coat cost $229. Are you going to the meeting this Wednesday at 8 a.m.? Sales tax on that item is $4.69, which equals 7.5%. The conference is set for 3 p.m. June 2nd. Paul's birthday is Saturday, May 5th. Most people dread April 15th. The total debt is $30,000, which is down from the original $75,800. Did you make the $1,789 mortgage payment on September 9th? Everything is on sale from Monday through Thursday. I paid $1,200 to have the car repaired. Sally was born at 2:55 a.m. on Sunday, October 27, 1991. They are holding a special meeting at 12 Tuesday, August 3rd. They gave me a 15% discount. Fred spent $500 on lottery tickets and won $100,650. Okay, these are words from our Tingle Tamers. For the record, abutment, absurdity, belligerent, bondsman, cannabis, careless, circa, citation, wager, objection, concurrent, hierarchy, narcotics, abolition, hypothesis, percentage, dilatory, magistrate, notary, embezzle, periodical, annulment, abrogation, obliterate, insight, default, quarantine, negotiable, gratuity, catchpole, canvasser, blasphemy, beneficiary, absentee, capitulation, intention, bailment, bequeath, boundary, capital, chancellor, leverage, rejoinder, plurality, retrospective, delusion, alienable, pacifist, absolution, copyright, registrar, extortion, pecuniary. Some more legal words. These are legal phrases. For the record, compensatory damages, acceleration clause, absolute privilege, authentic copy, reasonable notice, suspended sentence, judicial discretion, annuity contract, extrinsic evidence, equitable conversion, collateral security, matrimonial home, condition subsequent, chemical analysis, indecent exposure, obstructing justice, hostile witness, amended pleading, assessed valuation, exemptive security, presumptive heir, lease and release, civil contempt, compromise verdict, natural guardian, condition precedent, income averaging, direct examination, bill of particulars, honorable discharge, temporary alimony, real covenants, necessary parties, base period income, balloon mortgage, eminent domain. Okay, this is some jury charge practice for the record. Ladies and gentlemen of the jury, the trial will now proceed. You will first hear the opening statements presented by the lawyers. Each party has the right to make an opening statement for the purposes of outlining for the members of the jury what each party expects to prove. The plaintiff's lawyer will make the first of the opening statements. Then the defendant's lawyer may decide whether or not to make an opening statement. The plaintiff's attorney always has the right to start the opening statements. The plaintiff then has the opportunity to present evidence. Once the plaintiff's case has been presented through the testimony of witnesses and the offering of exhibits, the defendant will then have an opportunity to present their side of the story by presenting their evidence. Each witness is first examined by the party who calls that witness to the stand to testify. The first time the witness takes the stand, it is called direct examination. Prior to taking the stand, the witness is sworn in by the clerk of the court. After the witness has been taken on direct examination, then the opposing party is permitted to cross-examine the witness. Some witnesses may be taken on redirect examination and even recross examination. Those instances are rare, but they do occur. Some witnesses are even taken on voir dire examination, which may be conducted by either attorney. This also occurs very infrequently and is up to the judge whether voir dire is allowed. And ladies and gentlemen of the jury, do not get the voir dire examination of the jury mixed up with the voir dire examination of a witness on the stand. It is completely different. One takes place at pre-trial, and the other takes place during the trial process. During the trial, the lawyers may at any time make objections to the introduction of evidence. The lawyers may also make motions concerning the law. Generally, most arguments made in connection with objections or motions are usually presented outside of the hearing of the members of the jury. They may be presented at the bench or after the members of the jury have been excused from the courtroom. The reason for this is because questions of the law and the admissibility of evidence do not involve the members of the jury. Those questions are decided by the judge, who is sometimes referred to as the court. It is the duty for each lawyer to make objections and motions which the lawyer believes are proper. Do not be influenced by the fact that a lawyer has made objections or by the number of objections which have been made. The total number of objections should have no bearing on the case. Do not draw any conclusions from the rulings in this courtroom, either as to the merits of the case or as to any views regarding any particular witness. Once the evidence has been presented, I will then instruct you as to the law which is applicable to this case. Members of the jury, you must follow and apply the law as I will explain it to you. Once these instructions are given, the lawyers will then have an opportunity to make their closing arguments. During their arguments, the lawyers will point out to you what they contend and have concluded is the evidence and what it has shown. They will present their conclusions from the evidence that has been presented. The plaintiff's attorney will make the first of the closing arguments. Then the defendant's attorney will present a closing argument. After the defendant's argument, the plaintiff will have the opportunity to make a further argument in rebuttal to the defendant's argument. Now, members of the jury, remember that what the lawyers say in their opening statements, in their closing arguments, and when making objections or motions during the trial process, none of these is considered evidence. The reason that the plaintiff goes first in each case is because the plaintiff has the burden of proof. After the closing arguments, you will retire to the jury room. While in there, you will begin your deliberations. Then it becomes your function and responsibility to decide the facts. You must base your findings on testimony only, on the exhibits that have been received, on the stipulations of the parties, and any conclusions which may be fairly drawn from the evidence. This will be some congressional warm-up for the record. Mr. President, what we are trying to do is escape the responsibility that each of us took when we took our oath under the Constitution to protect our public and the Constitution of the United States. What we are doing is we are seeing a duck for cover tactic that I do not think in the final analysis is A, going to work, and B, going to answer the problems. Unfortunately, by the time the public learns what this amendment will really do, it may be too late. That, in fact, is admitted strategy of its proponents, and it is outrageous and abhorrent as a way to debate an amendment to the Constitution of the United States. We should be honest not only about the cuts and tax increases that are likely to result from this amendment, but also about the way the amendment would hamstring critical efforts to stimulate the economy during serious recessions. When the economy suffers a cyclical downturn, tax revenues go down, and spending for unemployment benefits and other items go up, so the deficit increases. Under this amendment, Congress would then have to make up the difference with measures that will stifle the economy even further. That is not good economic policy, and it will have extremely serious consequences for ordinary Americans. It will mean lost jobs and lost wages, and quite possibly could send us into another Great Depression before we would know what hit us. Having lived through the Depression as a child, I can tell you that is something to avoid like the plague. Let me discuss another aspect of this amendment that will take us backward. The amendment proposes to balance the budget by raiding the Social Security Trust Fund. Social Security represents a sacred trust between the government and our citizens. Often it is the mainstay of retirees. We have made a commitment, virtually a contract, with the men and women who have been paying into that trust fund, and so it is critical that we keep it off budget. If Congress spends too much on welfare or the military or farm programs, or if we give too many tax breaks to the wealthy, why should Social Security beneficiaries have to suffer as a result?